Start. Welcome everyone to part one of our Pathways in Dispute Resolution series by Houston Young Lawyers Association and HILA International Committee. My name is Paulina Rudnicka-Mauro, and I'm a co-chair of HILA International Committee this year and a founding attorney at Rudnicka Law Firm. I have a pleasure of moderating this webinar for you today. This session is recorded. Please drop questions into Q&A box anytime, and we'll take a couple after each section. Now I would like to present you with brief bios of our panelists for today. First, Justice Jerry Zimmerer, former justice of the Texas 14th Court of Appeals in years 2019-2025, known for timely, well-reasoned opinions. He holds a JD from South Texas College of Law and 2 LLM degrees in international law and in health law from the University of Houston Law Center. Judge is credentialed by the AA Institute in domestic and international commercial arbitration, and previously practiced as a litigator and business executive. Our second panelist, Chimdimma Onyedebelu, Director of ADR Services at AAA-ICDR Houston, administering large, complex commercial and energy mediations, arbitrations, and supporting arbitrator panels across Texas, Louisiana, Mississippi, and Alabama. She is a trained arbitrator and mediator. She previously served with leading ADR institutions in Nigeria and holds an LLB from Afi Babalola University and an LLM in dispute resolution from University of Missouri, Columbia. With the intro set, let's explore what mediation and arbitration look like in practice. Justice Zimmerer, please start us off.
Oh, the distinction between mediation and arbitration is actually, they're two completely different animals. So if you would, let me try to address some of the features of each. So a mediation is the nature of the process of mediation is collaborative and facilitative, whereas arbitration is adjudicative and binding and usually more formal. The roles of the neutral in a mediation is to facilitate dialogue and does not issue a decision. Whereas in an arbitrator acts as a private judge and renders a decision at the conclusion of the arbitration. The bindingness of the outcome in mediation is not binding, and also the communications in the mediation are privileged under Texas law and cannot be used in litigation. So the mediation is kind of a protected, safe zone so that the parties can meet and try to work out their differences, whereas an arbitration is actually a litigation type of process where the arbitrator issues a binding and enforceable agreement. And that is true both on a federal level, state, federal, U.S.-centric matter, but also in terms of international arbitrations, which is something we'll discuss in the third phase of our arbitration mediation discussions. The formalities in a mediation are informal and flexible, whereas in an arbitration, they are more formalistic, and it mirrors more of a lawsuit where litigation, where the parties present evidence to the arbitrator. Control over the outcome is different also. In a mediation, the parties are in absolute control over usually the manner and means, who the mediator is. The parties actually have a lot more participation in that. In an arbitration proceeding, once the parties agree on, or once an arbitrator is decided, then the arbitrator controls the proceedings and the outcome. Confidentiality is usually pretty much the same. In the first mediation, confidentiality is controlled by the parties. Typically in an arbitration, the arbitrator and the rules of arbitration determine the confidentiality of the nature of the proceedings. Appealability is obviously a distinction, although once you understand the nature of the cases, it's not that difficult. In a mediation, the appeal is basically to go forward, usually with trial. And in an arbitration, appealability is limited oftentimes to formation of the agreement, not to the actual proceedings and outcome. So anyway, and there's different use cases, as you can imagine, in different scenarios.
Thank you, Judge. Let's add to the institutional perspective of mediation and arbitration. Chi, would you like to tell us about this a little bit?
Okay, sure. So I'll be speaking from the institutional perspective, seeing as I work at an arbitral and mediation institute. So you'll hear me saying AAA-ICDR a lot. So just to clarify, that's the acronym for the American Arbitration Association and our international division, the International Center for Dispute Resolution. So when I say AAA, it's not the car people. So at the AAA, we offer administered arbitration, administered mediation. So you have a case manager that's working with you every step of the way through all the procedural milestones. So when we're looking at filing, so typically we start administering arbitration and mediation cases when we receive a demand. So it's honestly a really short form, probably like 2 pages. It just has like some pertinent information like name of counsel, name of the parties, any claims being asserted, preferred locale if your contract is silent on the locale, and your preferred qualifications in an arbitrator. So we want your demand. We want a copy of the relevant clause in your contract that gives us the authority to administer this arbitration or mediation. Then we want the appropriate filing fee. So you can do this either electronically through our electronic case filing system. You can send it by email or deliver it to any of our offices worldwide. So we have about 22 offices in the US and 1 in Singapore. So you can send it to any of our offices and we'll process that for you. So once our intake division has reviewed your filing to make sure that all preliminary requirements are met, to make sure that we actually have the authority to administer this case, it will then be assigned to a case manager. So the case manager will then reach out to the parties, introduce themselves, give you like some milestones as to how like this process is going to go. Then for arbitration, they will give the respondent a deadline to file their answer. So mostly, like especially looking at commercial, because I work in our commercial division, so mostly I will say our arbitration and mediation cases are largely clause driven. We do see a lot of party agreements. So like that's post a dispute, the parties will agree that, okay, fine, we're going to submit to arbitration and we'll have the AAA or the ICDR administer it. So usually they will send us that submission agreement. It can be pretty simple, just saying that we are going to arbitration, this institution will administer it. So they can send that to us, or if we don't receive that, we will send out like a letter with an agreement at the bottom, like, we received this filing. It doesn't explicitly say that we can administer it, but if you agree, sign it and return it to us by this date. If you don't, we'll close the case and give you back most of your filing fee. So it's mostly clause-driven, some party submission, and some are actually court-ordered. So the court will order them to arbitration to the AAA, will prescribe the parameters, maybe a single arbitrator. This will be the locale. Go to the AAA and report back at some time. So that's really how we look at administered arbitration and mediation at the AAA. So the case manager is just working you through all the procedural milestones. So working through the initiation, will help you with arbitrator selection. So for our large complex cases, that's any case with a claim of at least $1 million. The case manager will have what we call an administrative conference at the very beginning of the case. Talk to the parties, find out what exactly they're looking for in an arbitrator. So what qualifications do you want? You can be as specific as possible. We have over 5,000 panelists. We will find you what you need. So you can be as specific as possible. So depending on your contract, it might say that the parties will appoint their own arbitrator, or they will agree to a mediator, or you would ask us to provide you with a list. So once you've told us what you're looking for in an arbitrator or mediator, we will go back, look at our entire panel, and prepare a list for you. So we send that to the parties. You would strike everyone you don't believe will be a good fit, because arbitration and mediation, party autonomy is key. You control this process. The process is yours. So you'll strike everyone you don't believe will be a good fit, rank the rest in order of preference, and return it to us. So we will reconcile your submissions and appoint the most mutually agreeable arbitrator or mediator.
Thank you, Chi. I have two questions from the audience. First is to the judge. Judge, from the court's perspective, how do you see mediation and arbitration helping to reduce the backlog while still ensuring fairness for the parties involved?
Well, fairness for the parties involved is the easiest of that part of that question, because in a mediation proceeding, the parties are in control. There is no binding obligation to settle, and the communications are actually privileged under the law. So the judge that's presiding over your case that's being mediated doesn't know why the mediation settled or didn't settle. They only receive a report from the mediator that the case did settle or did not settle, and no other communication is, there's no talking with the judge that this party was uncooperative or this party is really in need, or any of those kind of communications. They're just, it's part of the ethics of being a mediator, is the confidentiality of the process. The other part of the aspect of your question, and now got so deep into that when I'm trying to remember the first part of your question. You would repeat.
Yeah, the first part of the question was from your court's perspective, how do you see mediation or arbitration helping to reduce the backlog while ensuring fairness?
Absolutely, absolutely. And it's such an important question. I'm so glad that we got a chance to revisit it. I did a panel, I was a moderator for a panel of district court, criminal court, district, family, probate, and juvenile judges, and it was really significant that, to what extent the judges rely on mediation. And certainly, if the parties are able to resolve their dispute, a couple of things happen. Number one, that their case goes away, it goes off the docket. Number two, it doesn't get appealed, because usually it's a settlement, it's a binding agreement between the parties. So the case is really finalized, and it's very important for the parties. That's the one thing that mediation does allow the parties to do, is to have finality. But it also, the role of the mediator is to help them do a risk analysis so that maybe adjust their thinking on what the value of their case is. But lastly, one of the most surprising responses I received was from a family law judge. And so I was sharing with them that I thought that the nice thing about mediation is it saves taxpayer dollars. So everyone should be in favor of mediation because it saves taxpayer dollars. But the family law judge shared the importance of mediation, particularly between spouses that involve children. And what she shared was striking. She shared that if the parties are able to mediate their differences now, it saves the court 18 years of ongoing disputes between the parties. And that's the life of the children continuing to be under the jurisdiction of the court. And that, to me, was striking. If you can get, particularly in family law matters, the parties to be able to mediate and agree between themselves, it saves 18 years of ongoing litigation. I hope that helps.
Thank you, Judge. Yeah, this is an impressive number. We have one more question, and this one is directed to Chi, and concerns particularly complex commercial or energy disputes. So, Chief, please tell us from your institutional side, how does the AAA work to ensure neutrality and balance in the selection of arbitrators in complex commercial or energy disputes, especially that you mentioned that you have such a big selection, over 1,000 of arbitrators?
Thank you, Paulina. So I'll start from our panel recruitment, then I'll go into arbitrator selection for every specific case. So panel recruitment, we have people apply to, be on the panel, arbitrator, mediator, international, domestic, various regions. So at that point, we're not really looking at where are you connected to. We're more so looking at your expertise. So subject matter expertise. Do you have a good reputation? If we Google you, Are we going to find any red flags and such? Then are you an efficient process manager? So then when we get to the case, so let me start with arbitrator selection. So we will give you that list. You will look through, we give you their resumes, we give you their rates. The parties will look through and, you know, pick who they think will be a good fit. So once we've appointed the arbitrator to the case, we invite them to make very, very detailed disclosures. So we have a whole host of questions. They are very familiar with our guidelines, so they make detailed disclosures like, do you know anybody on the case? Do you have any business relationships, personal relationships with counsel, with the parties, with any disclosed witnesses? So based on what comes back, so if they don't have any, they'll let us know. We have no disclosures, we'll inform the parties and we'll move forward. If they do have disclosures, we send this out to the parties and give them some time. So for our large complex cases, we give them 7 days. Please note that the arbitrator has disclosures, review them, and let us know if you have any objections. Now, at that point, the arbitrator doesn't know anything that's going on. Another beauty of administered arbitration, we handle all of this, so you're not objecting to the arbitrator's face. So the parties will then let us know if they have any objections. If they do, our administrative review council, it's like a committee of senior AAA and ICDR executives will review the party submission. So we have them send the objection. The other side will send their response. We review everything. Then we make a determination as to whether we will keep the arbitrator or remove the arbitrator. And it doesn't end there. The arbitrators know that till the award is issued, you have to continue making disclosures. So if new things come up, maybe new counsel comes on the case, you have to disclose, and we do that process all over again. And the whole time we don't let the arbitrators know what's going on. So they are like almost in la la land, like you just don't know what's going on. So you can maintain that, you know, neutrality. You don't know if anyone objected to you, and we handle all the processes.
Thank you. This sounds like a very thorough process. Thank you. Okay, let's now move to pathways and qualifications. Chi, could you please take the lead and tell us a little bit about training and credentials and what programs to use to become an arbitrator? Because I think that this is what our guests today are the most interested about.
Okay, perfect. So let's start with pathways. So building your career in mediation and arbitration. So I'll start with mediation. So for mediation, the global standard for basic mediation certification training is 40 hours. Same in Texas. So the Texas Mediator Credentialing Association, whose mission is to promote quality of mediation throughout Texas, the standard is 40 hours. So I know there are various organizations across the state, you know, that offer these trainings. In Houston, like the AA White Center that the judge trained at, they do offer this training. I think there's maybe one of the most popular in the city. So they offer the training, a basic 40-hour training in mediation. South Texas College of Law, I believe they also have a training program, but I think it's only open to attorneys. So if you're looking for training programs, check their requirements to make sure you're like the good fit for it. And I also believe the Harris County Dispute Resolution Center also offers a 40-hour training about once a year. Then for arbitration, again, AA White Center offers a commercial arbitration training that covers both domestic and international training. I believe it's 2 days. They host it once a year, and it's actually led by one of our arbitrators, Anne Ryan Robertson, who will be on the 3rd session. So please attend that at Baker Botts. She will be there. So she runs that program. Then the Chartered Institute of Arbitrators, which I took back when I was starting off my career, like 8 years ago back in Nigeria. The Chartered Institute of Arbitrators, they're headquartered in the UK, but they have branches all over the world. Their training is very thorough. It's very, very good. They have 4 levels of membership: student, associate, member, and fellow. And the student membership is free. All you have to do is prove that you're actually a student, which if you're actually a student, shouldn't be a hardship. Then the associate, if you're like starting your career off in arbitration, recommended to do that. The member, you're growing, then the fellow is like the highest level of membership for now. So there are some programs that you can really get involved in. It's not about getting the certification, but you actually learn so much. You meet a lot of amazing people. You get to join some great networks. So it's like you're setting yourself up for success.
Thank you. These are very useful information, and I would like to let everyone know that after the webinar, we'll send the resources by email to everyone. So don't worry that you didn't take notes of everything. Thank you, Chi. Justice Zimmerer, or would you like to add your bench and bar perspectives on ethics and credibility?
Oh, Well, certainly when a judge appoints you as a mediator, a court-appointed mediator, as I have been, the judge's reputation is kind of imputed to you a little bit. It's very important that you maintain your impartiality and that you work well with the parties as best you can. Now, I put that as best you can because many times parties in litigation are represented by attorneys, and not all attorneys view the mediation process the same. So it's important for you to maintain your impartiality from the court, but at the same time insist that they comply with the orders of the court. And sometimes those orders are very strict as to when and how the mediation can occur. And the parties aren't quite ready for mediation. So there's some requirement to be flexible, but you still have to comply with the order that appointed you. And so there's been some issues there that mediators experience. So you have to be aware of your obligation, not just to the parties and to the process, but also to the court, because they're appointing you. So your name and your reputation is important, not only to you, but to the court. I know that they're looking for people with impartiality and neutrality. They're looking for mediators that can respect the confidentiality of the process. They also understand that to some extent, the parties are voluntarily participating and hopefully have informed consent about the process, but we usually do that in the beginning of the mediation if they're not familiar with it. Certainly competency and diligence in performing the services, and finally transparency and disclosure, particularly with the parties, so that everything is done above board.
Thank you, Judge. And again, we have some questions from the audience, and I will start with Chi. Chimdimma, you mentioned training and credentials as a foundation, and I think you mentioned many opportunities, but there is still a question from audience, and many are wondering, how do we recognize which program or opportunity is truly respected by the court or an institution?
Okay, so I'll probably let the judge talk about what's respected by the court since he knows more about that, but let me tell you from the institutional perspective. So we're not really looking at branding so much, like, okay, you need to have been certified by the biggest, most expensive association in the world. No. So for mediation, I mean, you do need to have that certification to practice as a mediator, not so much for arbitration. So of course we do need that. So all you need to do is, for mediation, take a training with the organization that has the approval. So look at their website, make sure, I even think for Texas, you can go on the Texas Mediator Credentialing Association website, and I think they have a list of like approved programs. So you can check that just to be sure you're not, spending money on something that won't be recognized. But institutionally, we just really want to know, what do you know? What can you do? Where's your expertise? Where does your expertise lie? Like, how many times have you done this? Because more so for arbitration, when we're adding people to the panel, we're really looking at, do you have experience? Because currently we don't teach you how to be an arbitrator. We won't teach you how to be a mediator. We already assume that you have this experience. You're now bringing this experience to us. So for mediation, there is something new that we're offering for our mediation teams, offering now for consumer cases. So as long as you have the certification, you can be considered for the consumer mediation panel, because especially with our mass arbitration filings, it's a lot. So we are looking for more expertise. We're looking for more capacity. So that's something that can be considered. But for arbitration, you do need to have the expertise. So just, pick the one that makes the most sense. You can talk to people, reach out to, experts in the field, people you see on LinkedIn that have done a lot of this, and ask them like honest opinion. Like, I'm looking at these maybe 3 options. Which one do you think is not just the best use of my time, the best use of my money, and will actually be worth it in the end?
I understand. Thank you. And Judge, what is your perspective, court's perspective on this?
On the qualifications, or
on the best programs and the best opportunities that are truly respected by courts, by institutions?
Well, certainly any of the major organizations. Let me start off by saying that mediation does not require that you have a law license. So if you are interested in mediation and you are a non-attorney, I'm going to suggest that you get involved with the Harris County Dispute Resolution. I know that this is on the internet and that there may be people in other parts of the state or even other parts of the globe. Certainly, there are dispute resolution centers all over the globe. Every court, I imagine, across the globe has some sort of dispute resolution center or service relative to low dollar cases. And they might be family law cases. They might be what we call JP cases, or, where their parties are not represented by attorneys. You could certainly start by volunteering there and see if this is a good fit. I also know that labor disputes are oftentimes mediated by non-attorneys, and that's people that have some knowledge or expertise of labor relations and maybe grievance issues. But as far as the courts are concerned, we're typically looking for attorneys that understand legal issues. So that's where the disputes are that the courts are focused on. And how do you get experience in that area? I would suggest that you find your local bar association and see if they have a dispute resolution or an ADR, alternative dispute resolution committee like the Houston Bar does, and start attending their luncheons or meetings and certainly join the section. And then chat with us while you're there. That's what the attorneys do. We share experiences, and then you can look to see. It also kind of depends on which areas you're interested in mediating. Are you just generally general mediation, or do you want to go into energy, or do you want to go into personal injury, or what is the nature of the type of mediations that you're interested in working with? And if you have some degree of background or experience in those, that's typically what the courts are looking for, is somebody that's been an experienced lawyer and can be able to work with the parties. I don't know if that answered the question as fully as you intended, but
yes.
So.
Yes. Thank you. And I really like this advice to volunteer first, because I think this is a great way to see, is it for me? Do I like it? Is this how I imagine it would be? So I'm definitely for volunteering. We have a couple more questions. And this one is again to Chi. What are common mistakes you see early career practitioners make when they are applying to join institutional rosters, and how to avoid them?
Okay, so I think I'll probably say one of the most common mistakes when you're applying to join a roster is you don't have the experience and you're applying, or you're applying to the wrong roster. Like, I mean, some of them are like more international, some are domestic, some are maybe industry specific. So if you're applying to maybe an international roster, you don't have the experience, like there's a very good chance you're not going to get the response you want. So instead of like sending out your applications to so many places, take the time to actually build up your expertise. Like the judge said, volunteer, go to a lot of your local bar association events, go to HILA events. HILA is an amazing place to meet people. You meet people that you can even, talk to, start building mentorship opportunities. You can shadow some mediation and arbitrations. We have a new ADR committee, so, get involved, learn more. So wait until you have the experience before you apply. Yeah, so that would be maybe one of the most common pitfalls. And the second one is trying to be more so a jack of all trades. So establish your brand. So, I mean, you want to be a jack of all trades, you're spread so thin, nobody can really understand what exactly is your expertise. So if it's energy, then let it be energy. Tailor your application to that. If it's, franchise, if it's cannabis, if it's sports, figure out your niche. I mean, it doesn't have to just be one. You can, of course, have maybe 2-3 industries you specialize in, but figure out your brand, figure out what exactly it is you want to do, then tailor your application to that. Because it's just so general, because when we're reviewing these applications, we're not just looking at subject matter expertise or your efficient case management skills, we're looking at our regional caseload. So the application will come in, I will look at my regional caseload. Okay, do I need a person with this expertise at this particular time? Because we don't want a large panel of people that are just sitting there and we can't properly utilize you. So make your expertise very clear in your applications.
Thank you. This is a great insight. And we'll take a couple more questions. These are directed to Judge Zimmerer. Judge, from the court's viewpoint, what signals to you that a new mediator or arbitrator is credible and trustworthy even early in their career?
Ooh, that's a great question. I think it's a desire to be engaged in the process. And so if somebody were to meet me at a social function, say, or something of that nature, and demonstrate some of the qualities that we're looking for in mediators, I would be more inclined to give them an opportunity on a kind of a low risk mediation and allow them to have some experience that way. So we're aware that it's not always we're not going to send every case to only the few people who are top of the list. In fact, in Harris County, we use a round robin process where you get on the list and the list will go around and eventually come back to you. So you can get some opportunity that way.
That's good to know. Thank you. And one more question to you, Judge, from our audience. For those of us who also litigate, mediation experience can be valuable. How do you see lawyers using those skills to strengthen their advocacy while staying within ethical limits?
Oh, I don't see them. I don't see them as contradictory at all. Oh, I suppose if your position is, let's say that you're always a plaintiff lawyer or you're always a defendant lawyer, probably not the best person to be a mediator. But that is a reputational issue, and I think that can be overcome. I don't think that just because you practice in an area and these are your clients, that necessarily reflects upon your individual values. It may be that you can bring that expertise and understanding to a case and chat with the parties and be able to communicate with them about the specific details of the case. So this in a personal injury case, is this a high dollar case? Is it a low dollar case? Let's talk about the nature of the liability, the nature of the injury. It might be that you could actually bring some expertise to that. I think you would want to communicate that in your resume to the judges. That while my experience is primarily on this side of the bar or that side of the bar, that your role as a mediator is completely different. I personally, I'll share I do this in every mediation. I do share that I am a former justice on the Court of Appeals and am accustomed to making final decisions and actually rendering an opinion on what the law is and how it is applied to the case. But they don't need to be afraid, because in this scenario and under these circumstances, they have control, and I will not be making a decision on behalf of the parties in this case. And that's one of the first things that I point out in my mediation. So they're aware of my background and experience, knowledge, but that I'm not going to be inserting myself into their mediation.
Okay, thank you. So transparency is important as well.
Sure.
Okay. I think if we don't get to other questions, we'll circle back to at the end to them. Let's move on to skills training and building on ADR career. Chi, could you help us with this topic a little bit?
Yeah, sure. So you decided you want to be an arbitrator, you want to be a mediator. How do you start, developing? How do you start building those skills? So of course, number one, training, identify trainings, take the training so you can learn more so, then you move on to the next step. So volunteer. Like once you're starting off, I mean, yeah, volunteering doesn't pay the bills, but you volunteer your services, get involved in bar associations, attend events, volunteer to help, like speak at events, publish articles. That way you keep building your brand, you keep building up your knowledge base. People start to, recognize your name. People see you at events, they start to recognize you. They want to involve you in their projects. Then if you know of any like arbitrators, mediators, reach out to them and ask them if you can shadow some of their cases. All they have to do is really just get consent from the parties. So let's speak with the parties. Like I have maybe this mentee, intern, however they decide to, brand it, that would like to, observe some of these processes. And usually the parties don't really have a problem with it. So you can observe, you can actually see mediation, arbitration in action. You can begin to identify your style, what works for you, what doesn't work, and you just get more comfortable. You gain experience that way. Another way is by serving as an arbitral secretary or arbitral registrar. So this is honestly more common in international arbitration. Since I've been in the US, I haven't seen it utilized that often. But I know I have served as arbitral secretary a couple of times, and it's a really good way to, to learn more about the process. You are involved, you're working with the tribunal, like, you're taking notes, you're helping with scheduling, receiving filings and all of that. And most times you get paid for doing it. So you're getting paid, you're still building your experience at the same time. And then for business development now, so your brand. LinkedIn is an amazing resource. Use LinkedIn, build your profile. You'll be surprised that a lot of opportunities can come to you through LinkedIn. Then even at the AAA-ICDR, like we have a lot of resources and some of them are free that we offer you to continue learning, meet people, network, build your brand. Like if you go to our website, to our education services page, I can pop the link later or we'll send it afterwards, whichever is more convenient. We do have a lot of programs and some of them are free, or rather most of them are free because we are a not-for-profit organization. So we do have a responsibility to, to educate the public to keep, improving the practice. So a lot of them are free. We do have another program for students. We call it our Diverse Student ADR Summit. So we host it once a year. And our foundation will give like successful applicants $1,300 to cover their travel and their lodging. It's in New York at our head office. So you go out there for 2 days, you meet with, people from the AAA-ICDR, you meet with arbitrators, you meet with mediators, you meet with experienced, advocates that constantly serve on these cases. You meet with in-house counsel, you get to learn a lot about the process. So it's offered to 1, 2, and 3 law students. So you learn so much, you meet with people, you're expanding your network, you're already gaining mentors very, very early on in your career. So we do offer that. Then if you're not a law student, you have some experience under your belt, we offer the Higginbotham Fellows Program. Also once a year. I think the next program is going to be in May 2026. Also in New York. That one is a full week program, very intensive. And you also get to meet a lot of people. We even have staff that now work with us that came to us through the Higginbotham Fellows Program. So we have a lot of resources that we offer. Through our foundation, we fund a lot of programs. Since it was established in 2015, we funded over $12 million in grants. So even if you want to attend certain programs and maybe you're limited financially, you can apply. And if the funds are available, and it meets the requirements, our foundation will fund your conference attendance, your training, but it all has to be related to ADR. So you can't apply for something in, I don't know, sports law. We won't fund that. So it has to be related to ADR. So there are a lot of opportunities that you can use to sort of like start building your practice, getting to meet people, and sort of ingratiating yourself into the ADR world. It can be very interesting.
Thank you. Thank you. These are great resources that you mentioned. And now Justice Zimmerer, would you close our conversation with ethics and reputation tips? Because I think this is very important and many times forgotten.
Oh, ethics and reputation. I've heard it said that integrity is like a fine piece of china. Once it's broken, it's hard to put back together. It is important that you keep in mind the responsibility that you have to your profession. I don't think anyway, this is the Houston Young Lawyers. I don't think that there's anything that I can say that people are not already aware of as far as name and reputation. Whatever, hopefully you bring that kind of impartiality and honesty and transparency to the parties, and it is respected. I can share with you, it certainly is respected. I had to make many decisions as an appellate court justice that didn't please my friends all the time, but it is a reputation that was developed over a long period of time. And I'm certainly pleased that it is getting some degree of recognition now. Yeah, it is, you can't go into this with the idea that you're going to be the savior, or you're going to be influencing the decisions. You have to respect that the parties are in control in mediation. When you get into arbitration, that's a completely different story, completely different matter. But in mediation, it is the parties that control, and you actually get the opportunity to direct them and to help them reach agreements.
Thank you. And again, we have a couple questions, and I will start with the ones directed to the judge. What are the most common ethical missteps you have seen new mediators or arbitrators make, and how can we proactively avoid them?
So yes. So there's something called Med-Arb, where you are a mediator and an arbitrator. So you go into an agreement with the parties, and they say, well, we want to mediate this dispute, but if we're not successful, we want a recommendation, a mediator's recommendation, or we want an arbitrator. We want you to decide this case. We want some finality. So it's a Med-Arb. I don't believe that you can play the role of both the mediator and arbitrator ethically, and I'll share with you why. Because during the mediation process, you're telling the parties, oftentimes in where you go and have separate meetings with one party or the other, you're sharing thoughts and ideas with them, and they're encouraged to share with you. And you actually encourage them to share with you their position on maybe a settlement offer, or what their thought processes are on this issue or that issue. And they may actually even share with you that they have a weakness or a particular issue, and you bring it up and they say, yeah, that is a problem, and we're not ready to address that yet, but we recognize that as an issue, legal or liability or damages. And then you go and you meet with the other side. You can't share the information that they've shared with you in confidence. So I expect that everybody on this call would certainly understand that that confidence has to be maintained. But here's the ethical dilemma. And the ethical dilemma is that later, after they've shared with you confidential information, now they're asking you to be an arbitrator. They're asking you to make a final decision, and you cannot separate yourself from the confidential information that they've shared with you. And the reason why I believe that's so important, that you maintain that delineation, is if the parties agree in advance that you're going to take on that role as an arbitrator, then I believe that they would consciously or unconsciously not share, be guarded in the information that they do share with you. And I think that violates the nature of the mediation process. It's a real conundrum. And I know that parties do ask you to do that. But if they do ask, I think you need to let the parties realize that, are you sure you want to do this? you've shared some confidential information with me. Is it still okay for me to be an arbitrator in this case? So that's kind of an interesting dilemma. Let's see. I don't think that there's a whole lot of
Ethical missteps.
common missteps.
Mm.
I think one misstep is to allow the parties. Now, the parties agree, particularly in a court-ordered mediation, you have been appointed the mediator, and the court oftentimes sets time limits for the mediation to occur, like it must occur within 45 days of the order of mediation. It's very common in Harris County, and the parties haven't really prepared their case. They haven't done deposition, haven't done discovery, all of these kind of issues. And rather than just saying, oh, well, that's okay, you can extend the time, because really as the mediator, you're just as much under the order as the parties are to perform and to set the mediation to occur within that 45 days, but the parties may not be able to do that. So I think it's a common misconception that the mediator not engage the parties to force them to comply with the court's order, or alternatively to file a motion for and request an order modifying the mediation order. I know that's kind of harsh sometimes. Just because the parties aren't ready doesn't mean that the mediation can't occur. So then I do something that's kind of in between. I say, well, how about we get together and we'll do what I call an EDR. An EDR is an early dispute resolution where you bring the parties together and say, listen, we realize you're not ready to settle this and everything, although if you're willing to talk about settlement, we're ready to do that. But what steps need to be taken so that you will have sufficient information? What discovery do you need? What are the things that you need between now and then to finally get to the point where you can have a meaningful discussion about settling this case and put a real value on the case? And if you can get the parties to simply agree on what they each need, then that kind of EDR or early dispute resolution is a great way to get the parties to move forward. And incidentally, I have to put a plug in here for myself. One of the things that I do is I have a very inexpensive EDR, and it is intended to be very upfront. So I charge a very low fee for that. And then I give full credit for whatever that cost was toward the actual mediation, should I mediate it. Now, I feel like that's comfortable for me from a financial point of view, because I'm not going into the mediation cold. I've actually been engaged with the parties, understand the dispute, know what their issues are, know what the discovery and outcome is. And, do you really need all this discovery? Let's make the assumption for purposes of this discussion that your expert is going to say all of these things that expert must say to give you a cause of action, because that's what they're going to say. You're going to find an expert that says what you need them to say. Now let's talk about what you really need. You need maybe to depose a witness or depose the other side, but you don't need to wait on an expert report to go ahead with mediation or arbitration, mediation or EDR.
Thank you, Jed. This is I like it. This is very, very smart, and I think it serves like a status meeting for parties, so they can actually discuss where they're at and get encouraged to follow through with the mediation.
Yes.
Oh,
Actually schedule it right there. Well, he needs this deposition. When can you do it? When would you be? And actually schedule it during the EDR. And so then they've got it on their schedule. They've got it on the calendar. Then we'll come back and we'll do a mediation after that.
Okay, thank you. And let's take one more question. Actually, we have two. Let's see if we can take both. The first one is directed to Chi, and one of our guests is asking about the tribunal that you mentioned. If you could tell us a little bit more about this.
Okay, arbitral tribunal secretary? That one?
Yes, that's correct.
Okay. So as an arbitral secretary, you're there to support the tribunal. So there have been some, arguments about it, like, to the limits of the, the powers and the duties of the secretary. Don't become the fourth arbitrator. So you're not there to make any substantive decisions. You're not there to write the award. So there have been some instances that came up a while back, like, the arbitral secretary billed even more than the wing arbitrators. That's like the two arbitrators that's, work with the chair. So that came up that what exactly was this person doing that you're billing this much? So if you're actually, operating within the scope of your duties, you're there to support the tribunal. So when there are hearings, you're there. Sometimes you take notes, you help to follow up with the orders. So you send out the orders, you help with scheduling and all of that. And you most get paid. Like I said, it's very, very common in international arbitration. I think for domestic, since I've been in the US, because I've been in the US for a little over 2 years, I've only seen it once where an arbitrator had a secretary that was supporting them, not just as an assistant, but working with them in the case, like, to help with the orders. So we were getting the orders, from the secretary, like, oh, the arbitrator has prepared the order, it's been signed, take it. So I see it more so in international. So you can, work with people. It's a very, very good way to get involved. It's a very good way to get your name out there. And it's a very, very good way to get some experience. And it's not like, it's less pressure. You're not really making any determinations, but you're there in the room with them. You're listening to the deliberations. So you're starting to understand some of the thought processes, what actually goes on in arbitration. So you're essentially shadowing arbitration, but you're getting paid for it.
Yeah, that's a great resource, and it seems like it's a first-hand experience, but you don't have to be an arbitrator yet.
No.
Thank you. And we have the last question that we are going to take, and this one is directed to Chimdimma as well. If you had to recommend, no, I'm sorry, no, that one we already answered. So that's the last one. When you are just starting out, how can a new neutral, a new mediator or arbitrator market themselves ethically without appearing self-promotional or biased?
Okay. So I know globally there are very different standards for this. Like I'm from Nigeria, and back in Nigeria, even as a lawyer, you can't have a billboard. We call it touting.
The same as in Poland. Yeah,
Yes,
the same
you
as in
can't do
Poland.
that.
No advertisement.
So when I moved here and I saw billboards, I'm like, what is this country? So you can't do that. Yeah, but mediation arbitration is a different ballgame. So you can market your services. Like I do see like some of our panelists even like posting on LinkedIn, like a very good way. So it doesn't really seem too self-promotional. Speak, publish articles, like, you're publishing articles, you're contributing to, to thought leadership, and you're also getting your name out there. Speak at events, attend events, offer to moderate panels, offer to speak on a panel, even if it's a young professionals, like just build your way up. So like, try to get involved, speak at events. That way you're marketing your services, but also not too salesman-like. But I mean, you're also welcome to, do some brand. If you have a website, make sure your website is accessible, it's easy to read, it clearly states your expertise, ways people can contact you. I've seen some people that even have like their calendar available on their websites, so you can contact them through that. For our panel, we do try our best to market our panel. So we have like events, we try to get our panels lists on as speakers. So if you go to our website, you see you have a bunch of like, free webinars coming up and even some in-person events. We try as much as possible to utilize our panel because they are very, very good at what they do. And we want the world to know that. So, get involved, find ways to market yourself that way. So that way it doesn't feel like you're selling yourself too much, but you are still getting a lot of helpful visibility.
Okay, thank you. So let's conclude with some takeaways and resources from our session. So mediation is a party-driven negotiation facilitated by a neutral to help the parties craft their own solution, and arbitration is private adjudication in which a panel or a neutral renders a binding decision. Another takeaway from today is match the process to the objective. When speed, when privacy and relationship preservation are priorities, mediation often fits best. When finality, subject matter expertise, and a binding outcome are essential, arbitration is typically the stronger choice. Another takeaway from today is just start small, be consistent, select a good training to enroll, identify a mentor, a colleague, maybe join HYLA. If you haven't done so yet, meet some peers who are mediators, who are arbitrators, speak to them, contact them, be consistent, be ethical, and don't be afraid, and go out there, volunteer. Volunteering is a big part of gaining experience, and this is an important step that will give you a chance to build your resume, build your credentials. And another takeaway from today is that ethics defines credibility. Neutrality, preparation, and clear communication are non-negotiable. And how you navigate your gray areas ethically will build or undermine trust very, very quickly. And another thing that I wanted to mention that I believe there was mentioned by Judge today, that in mediation you have to respect that parties make the final decision, and in mediation you basically meet separately with the parties, and in arbitration you share your thoughts with basically everyone. So be mindful and do not make those two roles, as a role of a mediator and an arbitrator. I believe I do not have listed all of the resources that were mentioned by Chimdimma and by Judge Zimmerer, but I will mention a few and will email them to everyone after the webinar. And these are local bar ADR sections, AA White Institute, AAA public materials, law school CLE centers, and mentor programs, Harris County ADR section, and I believe that these are the most important that we mentioned. I think we are concluding our meeting. On behalf of our hosts, I would like to thank Justice Jerry Zimmerer and Chimdimma Onyedebelu for sharing their knowledge and insights, and to all of you for joining us today. Also looking ahead, this is not the last session that we are preparing. There will be a part 2, domestic applications of mediation and arbitration, and we'll build on today's foundation of the session with applied scenarios and tools. So we hope you can join us. And also in the chat, we shared the CLE code for this course. It's 174292093. And thank you for attending today, and enjoy the rest of your day. Thank you.
Thank you, everyone. Thank you, Paulina.
Thank you.
Guys, good job.
Thank you.
Thank you.
Great session.
Thank you,
Great
everyone.
insight.
Thank you.
Thanks so much, y'all.